I think you probably started off doing that for the wrong reason, and that's because you got caught again, and you're looking at 20 years in prison.
All right, everyone buckled up. This is one of those cases that shows how a long criminal history can eventually catch up with someone. In a situation like this, you'll often see multiple theft charges, prior felonies, drug issues, and years of probation attempts all stacking together. Today, we're breaking down how a person's past convictions, methamphetamine use, and supervision history can shape a judge's sentencing decision. Sticking around the twists in cases like this are surprising, and the legal lessons are huge. Who truly benefits from probation? And when does the law shift its focus from rehabilitation to public safety?
And sentencing on Daniel Ibarro. Okay, you're Daniel Ibarro?
Yes, ma'am.
And Mr. Ibarra was previously in court, entered pleas of guilty in cause numbers 24 DCCR 1722 and 24 DCCR 2289, both theft of properties. They were enhanced to second-degree felony offenses with caps of 10 years in each of those cases to run concurrently as the agreement. Is that correct?
Yes, Your Honor. Yes.
I've received the pre-sentence report as well as an update report that just has some more specific information from criminal history from Spokane, Washington. Did everyone get that?
Yes, Your Honor. Yes, they did.
Are there any additions or corrections to the pre-sentence report?
No to the offense, Your Honor.
Not from the state.
All right, Mr. Kimler, you may proceed.
Your Honor, PSI reflects extensive criminal history on Mr. Ibarra, which I suppose the court could infer from the fact that two misdemeanor theft cases can be enhanced up to second degrees, which implies that he does have extensive history. The facts of these two cases are both, as the defendant indicated in the pre-sentence report, that he was under the influence of methamphetamine at the time both were committed. It's not offered as a type of exculpatory evidence or even perhaps mitigation, but it does kind of explain why somebody with this criminal history would be doing.
Notice how the judge focuses not only on the theft charges, but on the broader pattern, the ongoing meth use, the repeated run-ins with the law, and the ever-escalating behavior. None of this happens in isolation. In cases like these, it's usually the culmination of a long history of legal trouble, sometimes even across different states.
What he's doing with a laundry basket and then some items from Walmart, all of which were under, I think, probably the Class B range of the theft. I would observe that there appears to be $300 in restitution payable in one of the cases for the laundry basket. Obviously, methamphetamine, drug addiction, but for that, I think Mr. Ibarra wouldn't have been doing these types of boneheaded thefts. He's recognized that, and in counseling with him, he's done at least what I asked him or suggested that he do, and that's to go into an inpatient rehabilitation program, drug rehab program, to try to address the substance abuse issues that he suffered from really an early age, which is indicated in the report, in the pre-sentence report. That's been an ongoing thing almost his whole life, and I think he's done that. And he's I don't know if you could say terrified of going to prison, but certainly he doesn't want to go to prison. And I think he's willing to do what he needs to do to stay out of prison, to comply with any terms of probation that the court assesses. He indicates to me that he is drug-free, which obviously if he drug tested him this morning, that could be corroborated. Or not, if he's not drug-free this morning, I don't know. But I assume, I would hope that he is. And he would just like to address the court perhaps better than I, more articulately, to explain his position and why he thinks that probation's appropriate.
Are you wearing a drug patch?
No, ma'am, Your Honor, but I've been clean sober since July 8th.
Have a seat in the jury box. Let's get that checked first. Okay, so the test was negative. Mr. Ibarbo, you wanted to say something, sir?
You could address the court.
Yes, sir, I'm just, Your Honor, probably an alcoholic drug addict my whole life. I went through treatment. I reached the point when this case came about, everything, like the futility of it all was overwhelming. And anyway, so I've been cleaning souls since July the 8th. I go to AA regularly. I like it. It's where I belong. I've got a sponsor today. I'm walking the steps. I'm just going step forward.
Here's a real human moment. The defendant talks about recovery, about trying to find purpose, and you can feel the sincerity. It's powerful. But the court has to weigh that against decades of criminal behavior and a long pattern of relapse and reoffending. Rehabilitation absolutely matters, but in cases like this, timing is everything.
It was where I found a purpose that I've never had. And I think I could do well on probation. And hopefully one day save somebody else from doing another day, what I did. Which is horrible addiction. Now that's all I got.
Thank you, sir. Mr. Coleman?
Judge, I'll be brief. I think the PSI speaks for itself as far as criminal history. I would like to add, I have judgments here. I've made them available to Mr. Kimler for additional convictions that were either not included in the PSI or they could not confirm those. And for the record, Judge, I am speaking of a 2013 aggravated assault out of St. Charles, Louisiana, in which the defendant received a 6-month probation. Also, a 2008 possession of a controlled substance case out of Kansas, in which the defendant was revoked to 20 months. In a 2013 fleeing or attempting to elude out of Kansas, for which the defendant received 5 days. I think that one is actually reflected in the PSI.
Okay.
The 5-day one.
Yes.
Also, Judge, I have judgments out of Spokane, Washington, for 1, 2, 3 thefts. One from 2011, 2 of them, it looks like it was a concurrent 1-year probation in 2008, and also a 2008 assault out of Spokane, Washington, in which the defendant received 338 days. And I've marked them. I'm happy to offer them.
No objection.
I don't know that I need them. I've made the notes and we'll take that into consideration as well.
That's all I have. I think the defendant, given his criminal history, at the risk of sounding callous, Judge, I can get it. People are struggle with drug addiction all the time. But at a certain point, Judge, there comes a point where the consideration needs to be protected the public. This defendant's been having contact with law enforcement since 1988. And he has spanned at least 3 different states with his criminal behavior. Judge, he's fortunate to have a cap of 10. He's exposed to 20 years, Judge. I'm asking the court to sentence him to the 10 years.
$4.
This part makes the court's priorities crystal clear. Public protection takes center stage over leniency. Judges aren't simply punishing, they're assessing risk. And in cases like this, the scale speaks for itself. Offenses spanning years, activity across multiple states, and a long trail of failed probation attempts. It all adds up in the judge's calculus.
I'm guilty of all that. I'm sorry.
Texas, Louisiana,
I think you're all right.
Kansas, and Washington.
I'm very sorry.
Arkansas,
5, 6, or 5,
Alabama,
6.
I guess my biggest issue, Mr. Ebarbo, is, well, one of the biggest issues is I appreciate and I'm glad that you have done what you've done over the last few months. I think you probably started off doing that for the wrong reason, and that's because you got caught again and you're looking at 20 years in prison. It sounds like maybe you're doing better, and that's great. I just wonder why it's taken so long. It looks like you went to the Unity House back in 1986, and other than that, it's just, at some point, you've got to take responsibility before you commit an offense, not after. I've counted 24 misdemeanors. I think with some of the ones that Mr. Coleman has said, there's probably actually more than that. There were some records that couldn't be found from different states. They're probably looking at more like 30. 7 felony convictions. You've been to prison. It's just too much. And at some point, there has to be an end to what you're doing and get that help before you continue what you're doing. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 24, DCCR 1722, find sufficient evidence to find you guilty, and at this time find you guilty of theft, find your prior enhancement convictions true, sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 24, DCCR 2289, also finds sufficient evidence to find you guilty, and at this time find you guilty of theft and find those prior enhancements true. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. I've handed you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir.
So here's the real takeaway. In cases like this, courts often hand down multi-year sentences for each theft charge, usually running concurrently, along with restrictions such as losing the right to possess firearms. It's a clear example of how Texas courts balance punishment, public safety, and the defendant's efforts at rehabilitation, and how seriously they treat repeated offenses. If you found this breakdown as eye-opening as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom analyses.